So what Judge Bumate's opinion for the Ninth Circuit here basically says is that if a religious organization like Union Gospel Mission makes this decision that all of its employees have to be united in these religious beliefs and practices to accomplish their religious purpose, because these are religiously motivated, sincere beliefs, the civil courts rather can't get involved. Merry Christmas, and we are going to continue to say Merry Christmas aggressively until February 2nd when we hit the end of the Christmas season. So Merry Christmas and welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. Big cases this week that we wanted to make sure we cover, so we're going to probably try to keep them a little brief. As Joseph said to me right before we hit record here, each of these three cases could easily be a full episode worth of discussion. So we're going to start with a major Church Autonomy Doctrine case that came out of the Ninth Circuit last week. Then we're going to turn to another important religious freedom case that's pending before the U.S. Supreme Court and could continue to solidify the free exercise right to not have religious organizations and programs excluded from generally available benefits. And then we're going to finish up with a Wyoming State Supreme Court ruling on an abortion pill ban that I think says a lot about the state of legal philosophy today. So with a lot to cover, let's dive right into the first case. So we're going to be discussing a case called Union Gospel Mission of Yakima. I think Yakima is how you say it, but it's out of the Washington State area. So quickly, this is about the Church Autonomy Doctrine. It's not a normal ministerial exception case like we would normally see about when we're talking about employment decisions from religious organizations involving non-discrimination laws. So this is, in a way, uncharted territory. I think Judge Bumate, who wrote this opinion, actually says that this is a case of first impression, the way that they're deciding it. So it is a big issue, something we've covered a lot at Napa Legal, and I want to make sure we set the stage right before we briefly touch on what actually happened in this Ninth Circuit case. So the foundations of the Church Autonomy Doctrine, most of our listeners are familiar with this, but it's a doctrine that's kind of derived from both religion clauses of the First Amendment. And essentially what it does is it protects religious organizations from government interference in their internal governance decisions, their doctrinal decisions. And the end result is that civil courts are not allowed to decide certain religious disputes over who is a member, who is the proper leadership, who is the proper governing authority of a church, or certain internal discipline matters. These are areas that civil courts shouldn't have jurisdiction to decide. So in the origins of the Church Autonomy Doctrine, you have famous cases from the U.S. Supreme Court like Kedroff, the 1950s decision, and it's been about hierarchical governing decisions, right? Kedroff as were a lot of the church autonomy cases in this era, involved Russian Orthodox churches, where you had disputes of, you have the patriarch in Moscow, then you have the local bishops and priests and people who run the local church, and who has decision-making authority over title, right, to the property that the church is on, or hiring decisions. And the Supreme Court has rightly said, this is a church governance decision. Whether it's the Patriarch of Moscow or the local bishops in America, that's not a decision for civil courts. So until fairly recently, this has been not all, but most of the church autonomy precedent has been set on these kind of church governance hierarchy cases. There is a derivative doctrine to the Church Autonomy Doctrine, which you're all familiar with, called the ministerial exception, that is basically states that when a church is choosing its ministers, right, hiring, promoting, firing ministers, a religious organization makes those decisions and can have no interference from the civil authorities, right? Civil authorities are not fit to choose religious ministers, period. So we've had some interesting cases in recent years. Our Lady of Guadalupe versus Morrissey Beru is probably the most recent prominent example that has clarified that a minister is not necessarily just an ordained minister, right? There are people who are instrumental to the church, the organization's religious mission and work, such as like religion teachers, catechists, who are ministers, even though they're not ordained. Their title is not minister, but they're still covered by the ministerial exception, right? So, okay, if we have the ministerial exception for these hiring decisions, why do we need this kind of novel church autonomy decision that we have in Union Gospel Mission? Well, because not all employees of a religious organization are ministers, right? The religion teacher probably is. The history teacher maybe, depends what his role is like day to day. Then the substitute teacher, maybe so. The Billard case out of the Fourth Circuit said yes to a substitute teacher being a minister. But what about the IT guy? What about the janitor? What about the front desk receptionist? The reality is, as much as we push the ministerial exception, it's not going to include all employees of an organization. And that's long been a concern of definitely of Napa Legal and a lot of people in the religious freedom movement, that if a religious organization doesn't have the ability to hire all of its staff based on faith, based on the religious tenets, teachings, practices of the church or of the religious organization, you really have no ability to be an organization with a religious identity, right? Because if you can be forced to not discriminate, as it were, on the basis of sexual orientation, gender identity, religion, how could a religious organization possibly make sure that all of its people are believing and practicing the tenets of the faith, and so being a consistent witness to that faith? It's a problem. And this case out of the Ninth Circuit has the potential to be an answer to that problem with some caveats. So let's get into this particular case really quickly. So Washington State's non-discrimination law prohibits hiring decisions based on many things, but among them sexual orientation, right? So the ironic thing is, actually Washington shouldn't be a good test case for this kind of an issue, because Washington State's law, plain reading of it anyway, actually does have a broad exemption to protect religious organizations, right? So that religious organizations and their hiring decisions doesn't apply to them, these non-discrimination laws. However, the state Supreme Court, in a case a few years back, held that the exemption for religious organizations in Washington state law only applies to hiring decisions that involve ministers. I will say that that's an insane decision. If you read the statute in Washington, there's nothing about ministers. It's a religious exemption to the employment non-discrimination laws. And this Supreme Court case in Washington is in complete defiance of the text of the exemption to that law. Be that as it may, that is the precedent in Washington. And so the exemption for religious organizations in their hiring practices is quite limited. And that's how we got this Union Gospel Mission of Yakima case that we just got a decision from. So in this case, there's a Christian ministry, Union Gospel Mission of Yakima. They sued to prevent enforcement of these non-discrimination laws against any of their hiring decisions. And in particular, they were talking about two positions that Union Gospel Mission wanted to fill. One was an IT position, one was an operations assistant. The organization considers both of these to be non-ministerial positions. So Union Gospel agrees here that these are not covered by the ministerial exemption, it seems. So just for background, this organization is missionary. They preach the gospel. They also have a number of charitable endeavors. They serve the community through some housing programs for the homeless, a lot of support services to help addicts in their recovery. It's a really interesting organization. But as part of their mission, they've held that, well, for Union Gospel Mission to do what it's supposed to do, which is witness to the gospel to the addicts, the homeless, the poor, to everyone we encounter, everybody in the organization needs to believe and practice the Christian faith. And among those beliefs and practices is the belief that sex is only proper between one man and one woman in marriage, right? So that's going to run afoul of non-discrimination laws regarding sexual orientation, because Union Gospel Mission says, well, if people aren't living this way, right, sex is only illicit between one man, one woman within marriage. People who are in homosexual relationships can't work here because they hurt our witness to the gospel. So that's how we get where we are. And so Judge Bumate on the Ninth Circuit writes this opinion. It's really good. It's very interesting and potentially very important, depending on how it's applied and how it moves forward. But basically it says that the Union Gospel Mission, when this case goes back down, is likely to succeed on the merits of its First Amendment argument under the Church Autonomy Doctrine. Judge Bumate basically says what I had just said, that hiring employees that believe and live the gospel, right, including this belief that sex is only permissible between a man and a woman within marriage, that this belief from Union Gospel that having everyone in their employment believe and practice this way, this is necessary for the organization to spread the gospel, right? That's Union Gospel Mission's decision, that this is a necessary part of its employment practice. So what Judge Bumate says here is, well, whether having every employee believe and live this, even the IT guy, right, is that necessary to spread the gospel? Is it necessary for the organization to accomplish its religious purpose? These are religious questions. These are doctrinal questions. And therefore, for the civil courts to get involved, this is a church autonomy problem. For the court to come in and say, well, yes, for the guys who answer the phone, but the IT guy behind the scenes or the guy who gets coffee, like, no, those aren't necessary for you to accomplish your religious mission. Those are religious questions, and it's impermissible for the court to get involved in answering those. So what Judge Bumate's opinion for the Ninth Circuit here basically says is that if a religious organization like Union Gospel Mission makes this decision that all of its employees have to be united in these religious beliefs and practices to accomplish their religious purpose, because these are religiously motivated, sincere beliefs, the civil courts rather can't get involved, notwithstanding the non-discrimination laws in the state of Washington. So it's really never been done quite this way. I don't think we've ever seen a precedential opinion saying that the Church Autonomy Doctrine basically requires co-religionist exemptions to state non-discrimination laws. Judge Bumate seems to think this is a case of first impression. He says so in his opinion. So this could be a big deal. I just want to note a couple of caveats, and then we'll leave this for another day, because my guess is we will see more of this. Either we will see other circuits start to follow this precedent, or we will see another circuit not follow this precedent, which would also not be surprising. And I actually kind of hope that's the case, because I would like to see a circuit split and to see something like this go up to the Supreme Court, because I think it is a church autonomy expansion clarification that the Supreme Court would be interested in weighing in on. So a couple quick caveats on what this case does and doesn't mean. First, it's a Ninth Circuit opinion, so it's weighty. It's going to get nationwide attention, but it's not a nationwide precedent, right? So that doesn't mean that the Church Autonomy Doctrine now protects these kinds of hiring decisions across the country, right? It's a circuit opinion. Second, what Judge Bumate's actual holding in this opinion says is that the Church Autonomy Doctrine requires this kind of co-religionist exemption, right? Which we typically read, the more narrow reading of co-religionist exemption is that you have the right to hire members of the same religion, right? Or to prefer members of the same religion in your hiring practices. But the way Judge Bumate talks about this exemption under the Church Autonomy Doctrine seems much broader, right? It does not seem to me that it's a strict to like, okay, Union Gospel Mission can hire people who are baptized Christians. It seems to go much farther and say they have the right under the Church Autonomy Doctrine to hire people who subscribe to their particular beliefs and practices, right? And that's an important distinction, because like a quick example, Catholic school having a co-religionist exemption in the narrow sense, right, might mean that, okay, you're free to hire only Catholics, right, to refuse to hire non-Catholics, that's fine. But what if you have a baptized Catholic who's received all the sacraments and goes to church every Sunday, but is not living the church's teachings on sex and marriage? Can you fire him? Broad reading of the co-religionist exemption says yes, because this is a religious question, but the narrow reading of the co-religionist exemption says, no, he's a Catholic. I mean, this is a fight. So again, I think Judge Bumate's opinion is broad. He says pretty clearly that it's not about defending the right to hire people from the same denomination. It's about the Church Autonomy Doctrine allowing the organization to determine what religious beliefs and practices are necessary for employees. So I think it's broad, but I think future opinions will have to clarify that we are not using co-religionist in the narrow sense. Just my 2 cents on that, because that word co-religionist has created some confusion in state laws because it's not used the same way in all cases. Third, the opinion is clear that it only applies to hiring decisions made based on good faith religious beliefs, right? So this is narrower than the ministerial exception, just worth pointing that out. If somebody is a minister, then under the First Amendment, the organization can hire or promote or fire a minister because they don't like their face, right? Like it does not have to be a religious reason. It's just the government has no jurisdiction to interfere with the decisions involving ministers, period. What Judge Bumate's opinion says here is that under the Church Autonomy Doctrine, non-ministerial employment decisions can be made based on religious beliefs. But he's not saying, therefore, that the Church Autonomy Doctrine allows religious organizations to do whatever they want concerning any of their employees, period, right? So it's narrower in what decisions can be made, even though it's broader in which types of employees it applies to. I know this gets a little bit in the weeds, but the distinction between ministerial exemption and this church autonomy line of thinking, it is important. And then last thing, it's unclear how broadly this will be applied to different types of organizations in future cases, right? Judge Bumate says, okay, involving religious mission organizations like Union Gospel Mission, yes, they are protected in their employment decisions under the Church Autonomy Doctrine. But he says in the case, and I'm paraphrasing, but we're not saying here that this goes beyond to, hospitals that are run by a religious organization or other types of institutions. So we don't quite know. I think he's just limiting himself to the case in front of him. My guess is that if this logic holds, then it holds across the board, right? That if there are organizations that are incorporated and operated for religious purposes, they would probably get the same protections as a matter of church autonomy, but we don't know yet. So he specifically says this is not necessarily applied to all religious organizations across the board. So I will stop talking here and say, despite the lingering questions that I've just laid out there, this case, Union Gospel Mission of Yakima, has the potential to be probably the strongest legal answer we've seen to how religious organizations can be allowed to live their faith through hiring, notwithstanding hostile state non-discrimination laws. So we've been following this issue for years. We've seen this conflict between non-discrimination law and religious organizations hiring and programming to be a huge issue. And we're really encouraged that there's potentially a church autonomy constitutional answer here that would provide protection for these religious organizations to hire and make these employment decisions according to their faith without worrying about these non-discrimination laws depending on what state they operate in. So I will take a deep breath, and I'm curious to hear you weigh in here, Joseph.
Absolutely, Frank. Thanks for explaining what's going on here. Getting into it in less than an hour is a bit of a project, so well done. And I would just take the opportunity here to talk about how the dispute that brought this lawsuit in the first place shows why state laws are so important. And I think we've talked about this before. Even while we have a federal government that, generally speaking, is pretty protective of religious liberty. Like you mentioned, through the statute itself is pretty good for exemptions for co-religionists, but through the Washington Supreme Court's interpretation of it, Washington law restricts the rights of religious employers to hire according to their faith. Now, like you said, in the Ninth Circuit, they ultimately ruled in favor of religious liberty in these types of instances. But we've seen other courts rule in the other direction. Even like we just said, the Washington Supreme Court ruled against religious liberty in these types of laws. So while this is a great expansion of church autonomy, it's not absolute. Like you said, it technically only applies to states within the Ninth Circuit's jurisdiction in particular circumstances and to particular organizations. Even aside from the positive outcome in this lawsuit, the punishment imposed by these types of states' laws is often just the costs of litigation. Not every religious organization has the capacity to take on years of court fights against a non-discrimination employment law. So not to throw cold water on this, it's a great opinion, great ruling. I'm excited to see church autonomy expanded to cover the religious hiring of non-ministers. But there is still a lot of work to be done at the state level for these types of laws. Right, there are other nonprofits in states with worse laws that might never get in front of a Judge Bumate. So great to see this, but definitely want to use it as an opportunity to talk about how there still is progress to be made really across the country on these types of state non-discrimination laws.
And I wish that I could shout out by name, but we have, I'm sure, a listener, but a friend of Napa Legal and a former Good Counselor Project fellow sent me this case literally within a couple of hours of it being released, which gave me a jump on being able to analyze and write on it and get it on this podcast as soon as possible. So you know who you are, and I know that you do listen regularly, so thank you.
Absolutely. Thank you very much. So next, we'll discuss a case currently pending before the Supreme Court brought by a Christian youth ministry. Now, this case isn't getting a lot of media coverage, probably because the fact pattern looks kind of familiar. There's a faith-based organization that was cut out from a government funding program because of its religious beliefs and subsequently filed a lawsuit. But if the Supreme Court takes up this claim, it could strengthen the First Amendment's protections in a new and hugely impactful way. So with that, let's get into the facts of what's going on here. So 715 Ministries is a Christian nonprofit that provides free mentoring and vocational training for at-risk kids. And for years, it received grants through the Oregon's Department of Education. They have like a youth development program funding. And in 2023, though, the department rolled out new requirements for grant eligibility. Basically, all applicants have to certify that they don't take religion into account when making hiring decisions. It's one of those, so-called non-discrimination laws based on religion. Basically, what it means is that a Christian organization can't hire according to their beliefs. And as you can imagine, a Christian nonprofit that interacts with highly vulnerable and sensitive populations like at-risk kids needs to be very deliberate with its staffing. And 715 had done this for years. They'd always hired basically only people that agreed with their religious beliefs, and they did that even while receiving steer grants. So in 2023, after this new requirement got rolled out, the Oregon Department of Education got an anonymous tip about the ministry's co-religionist hiring practices and rescinded all funding through this program. All in all, the nonprofit lost over $400,000 in grants, so it was a pretty big dent in their budget. Now, 715, after losing these grants, sued the department's director for violations of its constitutional rights, specifically free exercise, free association. And the third claim we're going to spend a bit more time on is kind of the newer thing that the Supreme Court can decide. It's one of religious autonomy. So in the latest decision, the Ninth Circuit's merits panel ruled for the most part against 715, who just recently appealed to the Supreme Court and is now pending cert. So I do want to spend just a moment on the Ninth Circuit's decision, but really for the purpose of getting into what's before the Supreme Court now that they can answer. So as related to the free exercise claim, there's a pretty straightforward analysis based on the Smith decision. The merits panel decided that the new requirements, so not being able to hire co-religionists, the new requirements were neutral and generally applicable, and thus were held up against rational review, which had been very easily passed. The Ninth Circuit did, like I mentioned, it was mostly against 715. They cabined this ruling by explaining that the religious discrimination restriction can only apply to activities that receive government funding, basically restricting a nonprofit's hiring practices in programs without any state funding would violate their free association rights. But now getting to the real meat of what's going on here in the new question, is that the panel also addressed the nonprofit's religious autonomy defense. So 715 claimed that the Church Autonomy Doctrine, here they're referring to it as the Religious Autonomy Doctrine because they're not a church, but it protects the rights of religious organizations to make internal decisions about its beliefs, like we just talked about in the last case, that doctrine prevents the department from enforcing these new requirements. And the Ninth Circuit actually dismissed this claim, and they didn't address the merits at all, but dismissed it from procedural grounds. So the court stated that the religious/church autonomy doctrine can't be raised as a standalone right forming the basis of a lawsuit. Basically, what this means is that the court decided that the right of a religious organization to make internal decisions about its faith cannot be invoked as the basis for suing the government over unconstitutional activity. So 715 claimed that the Oregon government's prohibitions against grant applicants' right to hire co-religionists violates their autonomy guaranteed by the First Amendment. And the court here didn't say yes or no. They didn't say that, yes, it violated your rights. No, it didn't. They're saying that you can't use this reason to bring a lawsuit in the first place. And that's the major question that could be before the Supreme Court if they take up its case. So while it is a mouthful, I'll briefly read the question presented in the cert petition. It says, quote, whether a religious organization can raise the First Amendment right to religious autonomy, so that's the Church Autonomy Doctrine, as an affirmative claim challenging legislative or executive action under Section 1983, like other constitutional rights, or whether the doctrine may only be asserted as an affirmative defense after a suit has been filed, as the Ninth Circuit held here. So basically, when a religious organization's rights that are protected by the First Amendment's guarantee of religious autonomy are violated, can they be vindicated in court? The Ninth Circuit held no. So I don't want to spend too much time on 715's argument about why church/religious autonomy can be a standalone right in a Section 1983 lawsuit, but I do want to just take a moment to outline their main claims. They start with saying that the U.S. has a history of shielding religious organizations' internal decisions from government interference. It is very true. And the Supreme Court, broadly speaking, has upheld this same right. And really the crux of what's going on here is that they're claiming that the Ninth Circuit attempted to rewrite the plain language of Section 1983. So as our listeners probably know, that's the federal law that allows people to sue the government when their constitutional rights are violated. Section 1983 says that a plaintiff can bring a lawsuit against another who, acting under the color of state or federal law, and this is the key language here, quote, cause a deprivation of any rights secured by the Constitution. So the deprivation of any rights secured by the Constitution. There's really just a simple three-step syllogism here that 71.5 is claiming. Step one is that the church/religious autonomy doctrine is a right secured by the Constitution. That's not really disputed. Second is that Section 1983 enables lawsuits against government activity that violates rights secured by the Constitution. Therefore, church/religious autonomy can be used as a standalone right asserted via a Section 1983 lawsuit. So long story short, basically, this Ninth Circuit ruled that you can't invoke the First Amendment's protections of religious autonomy as a right in and of itself to sue the government to prevent unconstitutional activity. And that's what the court can answer there. There have been other cases where we've talked about public benefits and religious organizations being restricted only because of their faith. And the fact pattern, like I said in the beginning of this, looks a little bit familiar. But the actual meat of what's going on here is kind of a new question. There's this ongoing debate about what the Church Autonomy Doctrine looks like. And here the court might have the great opportunity to explain a little bit more about when it can be invoked. So, Frank, there's kind of what I see going on. I'd love to hear what you have to add here.
Yeah, it's an interesting question. I'm going to limit myself so we can move on to the last case. But the one thing I think is we've seen different interpretations of what the Church Autonomy Doctrine is over the years. And that's a question that I don't know if this is the case to answer it, but I think it's worth pointing out here that what exactly is the Church Autonomy Doctrine? Because some people say, well, in the Ninth Circuit, I think said in this opinion that it's the Church Autonomy Doctrine is not a standalone right, it's an affirmative defense to a claim. Other courts have said it is not an affirmative defense, it's a jurisdictional bar at the beginning, right? Like you don't have to go through a case, let the plaintiff prove their case, and then defend yourself by raising, well, Church Autonomy Doctrine, that you can actually raise the Church Autonomy Doctrine at the beginning and say, listen, court has no right to hear this case at all because there's no jurisdiction over church autonomy issues. So I would say that either a jurisdictional bar or an affirmative defense is not quite the same thing as a constitutional right, like a free exercise claim. So it is a little tricky to kind of conceptualize how one does raise a church autonomy violation as a 1983 action. It's an interesting question. I hope the Supreme Court will take this, because I would like to see some clarity on what the Church Autonomy Doctrine is, how the courts view it, because it's not obvious. And the other thing that I think is interesting here is that and this isn't the way that the case as certified, like what's going up to the Supreme Court potentially characterizes it, but one thing that I think is interesting is if what you're saying here is, listen, if you have the internal right under the Church Autonomy Doctrine to hire co-religionists, which you very well might, especially given what we just talked about in the Union Gospel Mission case in the same circuit here. But if you have that right, it seems like what the government is doing here is saying, okay, well, if you have that right, we can still exclude you because it's not, we're not excluding you for being religious, right? This is a generally applicable law that says if you do certain things, you don't get these grants. And then it's interesting because, okay, you're not excluding people solely for being religious. You're excluding them for certain choices that only certain religious organizations make, right? Because like most Catholic charities, for example, don't actually discriminate and limit their hiring to co-religionists. They hire non-Catholics, for better or for worse, whatever you think about that. But so it's not across the board. But then what it's doing here, and I've just thought of this as you were talking, is that you're saying only certain kinds of religious organizations can actually apply, right? The ones that only hire co-religionists cannot apply for this program, but ones who don't limit their hiring to co-religionists can. And now it sounds a lot like Wisconsin Catholic Charities, right? Where the unanimous Supreme Court said, well, there's an establishment clause problem because it seems like you're giving religious programs of a certain kind this benefit, but not other ones. It's not an exact analogy, but it is an interesting problem here because it does seem like you're discriminating against certain kinds of religious orgs, particularly the ones that care enough about their religious identity to only hire co-religionists. And I could definitely foresee that being a problem, although that's not the way, it's not the argument that has been briefed to the Supreme Court. So as much as I would like to keep going on that one and go back and forth, let's move to our last case because we've already taken quite a bit of time and there's a lot to say here on this last case. So now we're going to go out of the federal and into the state courts. This is a Wyoming Supreme Court case, a disappointing one for several reasons. In 2023, Wyoming passed several statutes that banned abortion, which would include the abortion pill in most circumstances, right? There are some exceptions for rape, incest, supposedly life of the mother cases, and when a child is deemed likely to die within hours of birth. Be that as it may, in most cases, this law banned abortion. The Wyoming Supreme Court took up a challenge to that statute, or those statutes rather, on the grounds that it violates a fairly recent provision of the Wyoming state constitution. So the Wyoming Constitution has an amendment that was passed, I believe, in 2012 that says that each competent adult shall have the right to make his or her own healthcare decisions. Okay, so the court here claimed that abortion is healthcare, a personal decision of the mother, and as such, the bans on abortion under these recent 2023 statutes are in conflict with the 2012 constitutional amendment, which I believe is Article 1, Section 38 of the Constitution. And so the bans on abortion are subject to strict scrutiny. The opinion argues that the bans are not narrowly tailored because the exceptions do not further the state's alleged interest in protecting unborn life. So there's a lot going on here. The first thing I'll say is there was one dissent, although I didn't think that they dissented on the grounds on which I would dissent, which would be much earlier in the analysis. So the one dissenting justice said, Wyoming's Constitution said, here, let me find the language, sorry. The legislature may determine reasonable and necessary restrictions on the rights granted under this section of the Constitution to protect the health and general welfare of the people. So the argument here is that the abortion bans are absolutely necessary and in accord with reason, and thus would pass the strict scrutiny analysis required by the state constitution. So I'd point out, first of all, the lone dissent does not argue that the term healthcare in the constitutional provision excludes abortion, but argues that even if healthcare includes abortion, there's a compelling reason to restrict it. So I'm going to kind of use this as a springboard, because this case is what it is. You have 5 Republican-appointed justices who have all just accepted that the term healthcare in the Constitution includes abortion, and then went about explaining how they would analyze the challenge to the statute within that framework. I think that's wrong. So it is what it is. The court has decided that abortion is apparently healthcare for purposes of the Wyoming Constitution, and so these abortion restrictions were struck down. That alone is disturbing. It bothers me that every justice on the Supreme Court in a very conservative state, I think by some measures the most conservative state in the union, just went along with this idea that the right to healthcare includes the right to abortion without even much sensible conversation on why that is. So there's a case summary that was published by the High Court there in Wyoming that says the following. I want to read the paragraph here because it summarizes most of my issues. So, quote, in deciding what that language means in this case, all 5 Wyoming Supreme Court justices agreed that the decision whether to terminate or continue a pregnancy is a woman's own healthcare decision protected by Article 1, Section 38. Relying on law from earlier Wyoming Supreme Court cases, all 5 justices also concluded that an adult's right to make his or her own healthcare decisions is a fundamental right because of the very specific language used and because that language was put in a section of the Constitution called the Declaration of Rights. Okay. So you have a right to healthcare decisions under the Wyoming State Constitution. That's fine. It's a fundamental right. Also makes sense. It's in the rights section of the state constitution. But the fact that abortion is just considered part of this healthcare term is to me very problematic. And then there's a lot going on here. So I think that this dispute that's brought up by this case, I'm going to use it to springboard into a bigger conversation because I think this question of legal judicial philosophy is going to be really important in the coming years for reasons that I'll get to in a second. So I want to use an example. My friend who teaches at Regent Law School, Jeremy Christensen, who is a noted critic of originalism, pointed out at New Digest last week in an article called Abortion Originalism that was published on January 8th. He writes that first of all, like I said, all 5 justices were appointed by Republicans. All 5 seem to decide this case on originalist grounds. Jeremy's adamant that originalism itself is the problem. I'd say maybe, but I don't think so in this case because I think that this was an example of very bad originalism, even if you reject originalism altogether. So here's my issue. The justices decided here that healthcare does not exclude abortion. Jeremy argues that this is originalism as it's practiced by most originalist judges, textualist judges today. Be that as it may, even if that's how most originalists would read this constitutional provision, I would say that doesn't make it the only or the correct way of doing originalism, and I would say that in this case it's certainly not. So even by the court's own definition, right, they do the whole good textualist thing. They find a dictionary definition from 2012 when this constitutional amendment was passed, and the court says this. In 2012, the phrase healthcare was defined as efforts made to maintain or restore health, especially by trained and licensed professionals. They're citing Merriam-Webster's dictionary entry. Okay. If you take that definition, there's no reason to include abortion. Abortion does not maintain or restore health. It ends life. It ends an innocent life that is often not sick, so there's no question of health, and you're killing a person. So what's the health benefit? What is the restoration of health that's going on here? I don't know, but I would say that you could easily stay within an originalist textualist framework, look at the original meaning of healthcare in 2012 and conclude that no, abortion is not part of healthcare under this provision. Again, regardless of whether most originalists would agree with me, I think you can say that that is an originalist take. But I want to put that aside because I think there's a bigger question looming that I think Jeremy and a lot of similar people in the conservative legal world are pointing out that is important and is correct. So they've been raising this for several years, and in the end of Jeremy's article, he has a big question. Right? He says, is it really the case that whatever the people decide democratically is law? And I think we need to pay attention to that. No matter what you come down with as an answer, if the Constitution is amended, does that automatically make it law, valid law, good law? And you need to take it to extreme cases to ask that. I've used this before. This is an extreme case on purpose, right? What if the U.S. Constitution or a state constitution was amended to require abortion in certain cases, right? For example, to say that if a child is born with an IQ under a certain number, you must abort it. Is that a valid law? It's constitutional. I mean, if it's passed by a constitutional convention or by the proper constitutional channels, now part of the Constitution, there's no written law to stop it, right? So the question then that has to be asked, is there a higher law? Right? Is the natural law part of our legal framework, right? Does that apply? If you have a constitutional provision, which is the highest written law in the land, democratically, validly enacted, do we have any recourse to say that is not law? Like, we cannot do that as a matter of law. Or are we positivist, right? So if we say, yes, there's a higher law, natural law, that applies regardless of what the democratic process enacts in certain cases, like in my abortion requirement example, if we say, yes, there is a higher law that prevents this from being enforced as law, we come into tension with the most of originalism, and definitely with positivism, right, that says that law is what's enacted by the lawmaker, period. That's a broad brush, but basically. And if we say, no, there is no higher law, then we depart from the Christian legal tradition and we become positivists who hold that law is whatever the majority says it is. So I would say it's a timely question because this was not a huge problem for most of American history because most of our legislatures and courts and so on, lawmakers and leaders in general were traditional religious people in the way that they legislated, in the way that they thought morals and law interacted. So rarely would you find, right, an example of a legislature, before the last century, passing laws that we would say are in opposition to the natural law, right? So this question is going to continue to come up, though. It has should have in the last 50 years, 60 years, in a number of important cases. But as we continue to have governing majorities that likely will stray further and further from traditional and religious values, from the tenets of the natural law, we're going to have to face this question. If the highest written law in the land contradicts the natural law, what do we do? Is that the law? Do we have to be good positivist originalists who say, well, that's the Constitution, that's the law, we just have to apply it according to its original meaning? Or do we have deeper wells of law from which to draw as this continues to happen? So regardless of where you fall on this, I think it's really important that especially originalist, textualist Christians engage seriously with these criticisms of originalism and hats off to Jeremy Christensen. That was a really good little article, and I thought picked a good case to raise this point. So I could definitely go on. I think this is a really important question, and I think we probably will with future cases and future episodes, but I'll let you take us home here, Joseph, if you have any last observations.
Great. Yeah, thank you, Frank, for explaining both what's going on here and how it fits into this bigger debate within the conservative legal movement. There is, kind of bringing it back into this particular case, there is a really important point from the majority's decision about exceptions to bans on abortion that I want to spend a little bit more time on. So in this decision, the court ruled that the abortion bans fail strict scrutiny, in part because of the exceptions, right? These different bans had exceptions that said abortion is still legal in instances of where the child is conceived by rape, incest, life of the mother cases, which we kind of tackled last week. And then there's this other standard of fetal viability is what the label of it was, basically saying that if there is a live birth and the child is expected to die within hours of being live birth, if one were to occur, the abortion would still be legal. So the majority stated that these exceptions don't further the state's alleged interest in protecting human life. I actually agree at this point. The court said that if the goal is to protect human life, if the goal of these abortion bans is to protect human life, and that unborn children are human lives, allowing for abortion in these cases, especially the fetal viability one, makes no sense. If we're really going to say that we're protecting human life by banning abortion, how can we then permit killing unborn children solely because of the way that child came into existence? The outcome of this case is terrible. Wyoming's ban saved lives and was completely in accord with the requirements of Wyoming law. But the court's observation that permitting abortion in cases where the nature of the unborn child is the exact same as every other human life undermines our goal of protecting children is exactly on point.
Yeah, that's a great point to end on. And I will say that I think it's wrong to include abortion as healthcare under that provision of the Wyoming Constitution in the first place. But I do agree with you that if you are going to include it, that there's clearly that the dissent from Justice Gray is correct. That even if you grant that this falls under healthcare decision, that there's a compelling interest to protect human life, and that these statutes would still survive even a strict scrutiny analysis.
Yeah, absolutely. Like you said, the biggest problem here is the concept of abortion being healthcare is completely nonsensical, no matter what legal theory you apply to it. Just from a what is healthcare and what is human life theory, there's no way you can make those two things agree.
Yeah. Right. Well, we have covered a lot of ground, and we should wrap up. So we thank you for bearing with us as we covered 3 really important legal cases this week. More prep, more talking time than normal. So we're glad to keep you here with us, and now we will wrap. Thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you like and subscribe to our channel on YouTube, Spotify, or wherever you are listening from. And if you want to support the work we're doing or learn more about it, you can visit us at www.napalegalinstitute.org. Hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.